Cynthia Schendel, and I serve as the co-chair of the Social Work Advisory Committee of the Kansas Behavioral Sciences Regulatory Board. I ask the members of the advisory committee to respond to a roll call to signify their presence at this open meeting that is being conducted remotely by conference call and other electronic medium. Andrea Perdomo Morales, we know she'll be joining us late. Donna Honer-Quayle, Sarah Behrens, Jasmine Cohen-Young, Mary Gill, Mike Gillette,
I'm here.
Leanne Gingery, Yolando Johnson.
Present.
Thank you. Catherine Reich. Christy Sanders.
Present.
Good morning. Eric Schonecker.
Present.
And Robin Unruh.
Here.
Good morning. I note the following BSRB staff members are also present. David Fye. And is Leslie with us this morning?
Leslie is available to log on if needed, but otherwise she won't be joining us today.
Okay. Next, David Fye will read a message concerning this meeting being held remotely.
Great. Thank you, Cynthia. This is David Fye, Executive Director for the Behavioral Sciences Regulatory Board. Public comment allows the public to address the advisory committee about its concerns, but the Kansas Open Meeting Act, or KOMA, does not require the advisory committee to provide public comment or answer questions from individuals. Individuals requesting to provide public comment could contact the executive director prior to the meeting by sending an email to david.fye@ks.gov. There will be no public comment at this meeting as no individual is requested to provide public comment. Because we are conducting this public meeting remotely by conference call and other teleconference ability, I state for the record the following information. Public access to this meeting is being conducted by medium of interactive communication that allows members of the public without cost to attend the meeting through the use of the conference call and on the board's YouTube channel. While the meeting is conducted remotely, the requirements of KOMA are not suspended, so we will be conducting this meeting pursuant to the KOMA. On December 18th, 2024, we sent notice of the advisory committee meeting to all individuals who had requested notice of such meetings. The notice also stated, the notice was also posted on the board's website at ksbsrb.ks.gov. You may obtain a copy of the notice at that website. An agenda and other media material have been posted on the board's website and are available for review. You may also request a copy of the agenda specifically by sending an email to david.fye@ks.gov with the subject line request for the agenda, and it will be sent to you. The notice contains information for the conference call and YouTube channel that allows the public to attend the meeting free of charge. The notice also states that if we have any technical issues during the meeting, you may call the board office at 785-296-3240 or send an email to bsrb@ks.gov. A recording of the meeting will be available on the BSRB YouTube channel following the conclusion of the meeting by using the link to the meeting on the agenda. And I did check the conference call line before we got started. There's no one currently on the line, but if I hear someone beep over and introduce themselves or announce themselves, I will let you know.
Okay, great. Thank you, Dave. The first thing on our agenda is to approve our agenda, but I think we can't do that, right, David?
Actually, Robin Unruh was able to log in during the roll call, and so we do have 7 members.
Okay, great.
And that is a quorum, so we can take official action if you'd like.
Okay, wonderful. So if you've had a chance to look over the agenda today, I would entertain a motion to approve.
I approve.
Thank you. Do I have a second?
Second.
Thanks, Eric. All in favor? Aye.
Aye.
Opposed? Any opposed? Okay, agenda is approved. And next we need to approve the minutes from our last meeting, which was on December 10th. And those were attached to your email. Hopefully you had a chance to look those over. Are any corrections or changes that anyone needs to propose to those minutes from December? Hearing none, do I have a motion to approve the minutes as drafted?
Motion to approve.
Thank you. Any seconds?
Second.
Thank you, Eric. All in favor? Aye. Any opposed? Okay, great. Those minutes are approved. And now we will move on to David's report.
All right. Well, thank you, Cynthia. I'll go ahead and share some updates on BSRB operations, and then we'll touch on some legislative topics, and then I'll give you some updates from the most recent board meeting. So in terms of BSRB operations, just a really quick summary, we made a lot of changes over the last year. We've upgraded a lot of technology here at the BSRB office and also online. So we do have a new website that we launched in the summer of last year. We also have finalized our agreement and implemented an agreement with CE Broker for all professions. So we do still encourage licensees that have not already gone ahead and activated a free account with CE Broker to go ahead and do that. If you're not familiar with that, it does allow licensees a free portal to upload your documentation of completion of continuing education hours. I believe there's also information about CEs through that website. There are some higher level paid services, but when we made the agreement with CE Broker, we made sure that all licensees were able to have a free account. Now, if somebody wants to choose to do a paid account for more services, that's perfectly fine, but the free account for all licensees was an important part of our agreement. So we have that in place now too. We have also been finalizing a survey for most of the professions under the BSRB. Over the last few years, we have done a survey for social workers. I believe one was in January of 2022, and then we did another one just last year. And so we worked with each of the other advisory committees to similarly look at survey questions that involve things like telehealth, supervision, and also trying to more clearly define the workforce in terms of who's providing oversight to individuals and how much direct work people are doing versus telehealth. We collected a lot of really good information. Some of the questions also dealt with topics like artificial intelligence. And so we just recently closed those surveys. We're going to be trying to put that information together. Even though there was not a survey for social workers this round, I think you may find some of the interesting information we collected to be helpful. There are some similarities and common ground between the professions overseen by the BSRB. And since we did go ahead and have similar questions for about 6 professions, we're probably going to have some summary reports too. So that'll be something we'll work on behind the scenes. In terms of some other updates, I'll just turn to some legislative topics. This time of year, there's 2 main things that I'm at the Capitol for in terms of the legislative process. One is the budget for the BSRB. Every state agency is required to submit a budget. We did go ahead and submit a budget in September of last year. It was a revised budget request for the current year, fiscal year 25, and also a new request for fiscal year 26 and 27. The legislature is using a different process for the budget this year. Traditionally, the governor would come out with a governor's budget report, and then the committees on the House and Senate would make adjustments from the governor's recommendation. This year, what the legislature did is had some special committees meet in the fall, come up with recommendations as a preliminary starting point. The governor still did make recommendations on budget, and those were discussed during the budget hearing process, but their starting point was officially what the special committees looked at in the fall. So for the BSRB budget, the recommendation by the House committee that reviewed the budget, the House Higher Education Budget Committee, is the same amount as was requested by the agency. And happy to report we came in a little bit under budget from what we were approved for last year. So the amounts that we requested were approved. The Senate has taken a different approach than traditional. Usually they have committees meet at the same time the House does, and then they both have different positions that come together in different appropriations bills. This year, what the Senate decided to do was wait for the House to pass an appropriations bill. And then that bill did pass the House floor last week. And now it is being assigned to the Senate Committee on Ways and Means. And then they will be having separate budget hearings for a select number of agencies. And I was just informed the BSRB will not receive a specific budget hearing. So unless there are items affecting all agencies, our part of the budget process may be near complete for the year. So happy to report that. No changes this year, but we'll continue to watch for some of those globals if there are global recommendations by the Senate. And then that process hopefully will wrap up here in the next month or two. And then other items, the BSRB sometimes requests items for a bill on behalf of the board based on recommendations the board puts forward. There are a number of different items the board has requested in legislation this year. Unfortunately, based on the volume of bills the Office of the Reviser of Statutes received, Our bill was not available to be introduced until we were basically right past the deadline where we could introduce those bills in non-exempt committees. There are certain deadlines for introduction of bills. So we tried to get the bill introduced in an exempt committee on the House side, and unfortunately we weren't able to do that. So I've pivoted, and I had a conversation a couple weeks ago with a chair of an exempt committee on the Senate, and the chair is open to introducing the bill, but waiting to receive direction from Senate leadership concerning if there's any issue with admitting new bills this far into the session. So it's a different process in a lot of ways this session. Normally, we would have wanted to have a hearing and the bill passed on the House side by now or on the Senate and then moved over to the other chamber. If the bill is introduced, it'll still be an uphill battle trying to get the bill passed in both chambers. I just want to gauge expectations. But since the bill is already drafted by the revisor's office, if it doesn't move forward this year, I'm very optimistic that we'll be able to have it move forward next year. But concerning some other bills, if there are bills affecting the BSRB, sometimes the board can meet and provide direction concerning if the board would like for there to be testimony on a bill, either in favor of a bill or neutral testimony, or sometimes opponent testimony. And this year there has been a bill that affected social workers. It did get scheduled for hearing fairly quickly. And so I just want to put it on your radar and let you know that it is out there. This is a bill, and I'll go ahead and pull the bill number for you. But to briefly summarize the bill, as social workers, there are mandatory reporting statutes that social workers must follow. But in the past, there have been social workers who worked for attorneys. And the question was, are the social workers still responsible for following the mandatory reporting statutes if there is something learned through attorney-client privilege? And so basically the answer, as far as my understanding in the past, has been yes. And so some social workers have not worked for attorneys for that reason. And so there is a bill before the legislature this year, and it looks like that would be Senate Bill 128. And so what that bill would do would create an exception from the mandatory reporting obligations for licensed social workers who are being supervised by an attorney to permit the individual social worker to exert essentially a defense to not follow the mandatory reporting statutes if they learned information in that confidential context of having worked for the attorney. It would also allow the attorney to assert the privilege on behalf of the social workers working for them, where they would say this information was learned through the attorney-client privilege. So we would not want this information to be made available due to the mandatory reporting. So I understand that that bill did pass the Senate committee. It was in the Senate Judiciary Committee. The bill was also passed favorably on the Senate floor by a vote of 40-0. And I understand in that committee, it did receive some written-only testimony favorable for NASW Kansas. And so we're going to continue to monitor that bill. If that bill does pass both chambers and get signed into law, we may need to adjust the language of our unprofessional conduct regulations, because that regulation does make reference to the mandatory reporting statutes for social workers, and that it would be unprofessional conduct for a social worker to fail to follow those. There probably would need to be some additional language to clarify if this legislation does pass, that there are certain instances to where a social worker may be covered because of attorney-client privilege if the bill does pass. So I want to make you aware of Senate Bill 128.
David, can I insert something? Does anyone on the committee know someone or who has worked for an attorney that would be in this circumstance? Yeah, I don't either. So, David, in your bird dogging of this bill, did you come across any circumstance? And I mean, when would a social worker be working for an attorney where whatever they were doing for the attorney would have a higher ethical need than reporting abuse and neglect
Yeah,
of the vulnerable person?
I'm not sure of the specific instances. I did talk with Leslie Allen to see if this topic had come up in the past, and she said it had come up in rare instances where people had just, asked questions about it. But I don't know exactly in what capacity they would be working for an attorney. I can tell you one of the agencies that was pushing this legislation was the Board of the Board of Indigent Defense Services bids. And I think that they had presented either were proposing the bill be passed, or at least were supportive of the bill, because they did reach out to have a conversation with me about the bill to make sure that I understood it. So,
But they didn't provide you any examples of when this might come into play? And an
well,
attorney, a social worker would be working for an attorney and should be exempt from reporting child abuse?
I'm not sure of the specific roles that they would have working for an attorney. Um, but that is what it would cover. It would cover
Okay.
anyone who was a social worker, who was held to those mandatory reporting statutes, and but also held to the attorney-client privilege. And so I think this would, I think the intent is to kind of clarify a little bit of the push and pull by people who are obligated to report certain information, but then also asked to keep certain information confidential. So.
This is Mike. I can think of an addiction counselor who has referrals from an attorney to do an assessment of a client to determine what their addictive levels are. So then it would be child neglected, probably be possibly raised through that type of an interview. And if that became available, I would think that the social worker would be mandated to report the child neglect. But this law, I don't know if that would change that kind of thing. But anyway, that's a situation I could think of that might happen.
Eric, go ahead.
I think it's something for us to think about the ethics of that, because you obviously in your example, and that's a good example, Mike, that your client is the person you're assessing for their level of addictive illness, and you may learn about, but you wouldn't likely be in the employ of an attorney in doing that. The attorney would refer out to somebody who was a licensed addictions counselor, perhaps. But if by chance you were, and you learn, I have a problem with the idea of your assessment of that client falling under attorney-client privilege, because we're not attorneys. And our ethics, our code of ethics, doesn't allow for any exceptions to reporting neglect or abuse of the more vulnerable person. I mean, you can report it and also report that the client is seeking treatment, or, that this was in the past or whatever. But I have a hard time believing that we can satisfy our ethical responsibility under that circumstance. I don't know. Anyone else have a thought about that, or
I do. So one of the things I was thinking about is like parenting evaluations when but you could be working for an attorney and have it be a licensed social worker and be doing like an evaluation on a parent, and that parent is the client of the attorney, and they disclose, hey, I've physically abused my child. That would be damaging to the attorney's case for like reintegration, etc. So I could see where the law might be necessary. I don't know that it necessarily isn't wouldn't be an ethical issue, but it would also be one of those things where the attorney has an issue to their client, and then we'd be violating their, duty to their client by upholding our ethics or our ethics code. So I could see where that could be a scenario that could occur, but I would guess it would be exceedingly rare.
yeah, I mean, I think in most instances, because I dealt with a lot of divorce cases in my practice, and in most instances, well, in fact, I don't know of any where the social worker that was doing that kind of assessment was in the employ of the attorney or the attorney's office. Maybe that's part of their reason for wanting to get this in there, is that then maybe if the attorney does directly hire the social worker, then they could fall under this law and not be allowed to report that. But like I said, as a licensed social worker, I have a hard time. The code of ethics is supposed to be our guiding principle regardless. And I have a hard time legislating that away with the idea that somehow you can declare that it doesn't apply. Your ethical responsibility doesn't apply in this circumstance.
I agree, Cynthia, because I think we're ethically responsible as social workers, to protect our clients, and the clients that we serve. I mean, that has to be our top priority. So maybe the law, I don't know, the bill was put in place to make sure that, we continue doing that it balances that. The social workers that do work for attorneys, usually are, dealing with justice or in justice departments. And so, which I don't think that would apply,
You
but
would
I
think.
do agree with you, Cynthia.
Hmm. Okay, well, I mean, I can imagine that the BSRB may get some inquiries from social workers that might be considering employment with an attorney, about this kind of conflict between what this new law says, and it hasn't yet fully passed, right, Dave?
It's only passed one chamber. It was introduced
Right.
in the Senate Judiciary Committee, and it passed that, and it did pass the Senate floor by a vote of 40-0. But the next step it'll be referred to a House committee, most likely House Judiciary, and then it'll receive a hearing and then go through the same process on the House side that it did in the Senate side.
I wonder if you could reach out to Becky about why NASW is supporting this, and also to the indigent defense lawyers that you talk to, or the organization, for specific examples of why they thought this was necessary. What circumstances have they had this issue come up?
Yeah, and I understand NASW Kansas did provide some written only testimony at the Senate hearing. And I think BIDS provided probably oral and also written testimony. So I'd be happy to get that testimony and then forward it to
Please.
the committee.
Yeah. Yeah, and so we can maybe revisit that at a
Couple
future
of
meeting.
times that I've heard, like I do know that attorneys have employed social workers to work with families who are in the process of adopting. I
Sure.
can't think of, okay, then what would come up that they wouldn't then protect the child. But my experience with some domestic violence advocates is they're very passionate about, I'm not going to report something if it puts my client or the child or whoever at risk. And now whether or not they are licensed, I just know that was so I'm trying to think, like, what if it was a batter intervention, somebody that had charges or something, and this worker, normally, like, the attorney has a social worker who's, I don't know, doing treatment assessment or whatever. And then what if they probably would find something out that would be possibly reportable? And I would want to be in that position, but maybe it's possible.
Yeah. Well, I think it would definitely give pause to any social worker that was thinking about working under those circumstances. And certainly in an adoption study, if somebody who's seeking to adopt a child, and you discover they disclose abuse of children in some circumstance, that would definitely be an ethical issue to withhold that information, regardless of if this becomes law or not. I mean, I can't imagine that being the law being able to override that. But okay, well, we'll come back to that when we have a little more info. Dave, thank you.
Okay. And just to let you all know too, the hearing on that bill that did take place in the Senate Judiciary Committee, that was on Tuesday, February 11th.
Mhm.
And that is, it was streamed on the legislative YouTube channel. So if any of
Okay,
you could go back and watch the hearing as well to kind of hear some of the discussion that took place.
on the legislative YouTube. Okay, thank you.
You're welcome. And then just another bill I know there's been some questions about, and I can't definitively probably answer all those questions, but there was a bill that passed the legislature, Senate Bill 63. It is referred to in the bill, it is named as the Help Not Harm Act. And it would restrict use of state funds to promote gender transitioning, prohibit healthcare providers from providing gender transition care to children whose gender identity is inconsistent with the child's sex, and authorizes civil cause of action against the healthcare provider for providing such treatment. This bill, a lot of the language of the bill speaks of some prohibited acts. It talks about surgical procedures. It talks about prescribing medication. Some of the unprofessional conduct standards that are referenced in the bill relate to the Board of Healing Arts professions or other medical professions. But there is some broad language in the bill that talks about healthcare providers and talks about healthcare services. And so this is a bill that was fast-tracked by the legislature. It was introduced on a Thursday and immediately scheduled for a hearing on the following Tuesday in the Senate. It did pass out of the committee. It then went to the Senate Committee of the Whole and passed the Senate floor on a vote of 32-8. Generally, when something passes a chamber floor, it gets referred over to the other chamber, assigned to a committee, scheduled for a hearing. If it passes out of that committee, it goes to the chamber floor if they wish to run it across the floor. In this case, it was an unusual process. So that bill, when it passed the Senate Committee of the Whole or the Senate floor, it was referred over to the House Committee of the Whole and dealt with on the House chamber floor, and it was passed by the House by a vote of 83-35. And then it was presented to the governor's office. The governor vetoed the bill. Now on Tuesday, February 18th, the Senate overrode the veto on a vote of 31-9, and the House overrode the veto on a vote of 85-34. Most bills take effect upon publication in the statute book, which is July 1st. This bill had some different language that said it would take effect upon publication in the Kansas Register. The Kansas Register is a weekly publication by the Secretary of State's office. Usually when something is available to that office, it takes a little bit of time to format the bill to get it ready for publication. But as I understand, this bill was provided to them and then published very, very quickly. So it did get published in the Kansas Register as of Thursday of last week. And so it is now effective. And we've already received a few questions to the BSRB office. Unfortunately, this is a complex bill. It is difficult to understand what, if any, subjects relate to BSRB providers. So we are trying to work through this bill and make sure that we have a good understanding of it. So at the moment, we did have a special board meeting yesterday. The purpose of that meeting was for the board to receive counsel from legal counsel for the board. And that did take place in executive session under attorney-client privilege information. So publicly, the board has not, has not offered guidance on this subject. And traditionally, the BSRB does not offer guidance on legislation. We don't provide legal advice to individuals, but we also understand that there are a lot of questions about the possible impact of this legislation. And so I just kind of want to say broadly that we are continuing to work on this. The board is meeting again in a couple of weeks. We encourage everybody that if they do have questions, they may wish to speak with their own legal counsel to get perspective that way. It's just in this area, there's only so much information we can provide on behalf of the agency. So did want to make sure that you were aware of that bill. And then if there's any comments any of you would like to make, just kind of want to open it up now too.
So first off, again, I want to ask, does anyone here work with trans youth or anyone in your agencies? Nobody? Okay.
Yes, our staff would, not in like a therapy or counseling position, but yes, a lot of kids in foster care.
Oh, okay. Yeah.
Yeah.
Well,
I also work with a couple.
do you? Okay. So there were a couple of amendments that were offered while this bill was being debated that would have clarified that BSRB licensees were not required, or were not part of that, or were allowed to provide mental health care. They were all defeated. Those amendments were rejected. And so that's why what Dave's saying about it being very Pardon me?
I think
What?
there was some feedback. Yeah.
Oh, yeah. So that there, it's it isn't clear how much uh, we are under these requirements, and the language of what we aren't allowed to. The bill says, or the law now says, we can't promote or advocate any of these treatments that are now prohibited. So what we have to figure out is, what does promote or advocate mean, and how can we inform without being at risk as providers? How can we give information, and how can we document that that we're following whatever the requirement is? So that's what's going to have to get sorted out, and it may get sorted out by people challenging. There may be because this was a very purposeful. This bill, similar law passed last year, and they couldn't override the veto. This year they did, and they hit the ground running with this bill, intending to ram it through just like they did. But because of that, the language in the bill is not very clear and not implementable yet. We don't know what it means for mental health providers. So we'll be, possibly having some people that test this law, as in make a complaint against somebody and see what happens when it goes to court, and what the legal interpretation is, or, we could end up asking for a legal decision. I don't know, what we'll end up doing as a board. But it's something that is out there, and any of you that do work with trans youth, or that have people in your agency that do, I encourage you to stay tuned in, so that we can, convey whatever information we're able to come up with in the end, to provide any kind of guidance to mental health providers. Anyone have any thoughts about it, or comments, or suggestions for how we might deal with this? Eric, you said you had a couple of clients. So how do you plan to proceed?
So the clients that I work with aren't necessarily there because they're transitioning. They're there for other associated mental health things. So they
Mhm.
are transitioning, but it's not the subject of our treatment or care. So honestly, right now, with the way things are changing on an hourly basis politically, I'm just kind
Mhm.
of being very conscientious about what we cover, how we cover it, and just waiting to see what actually
Mhm.
comes through.
Yeah. Right. And so the issue will be any client that has a diagnosis of gender dysphoria could become a subject of scrutiny as to whether or not they're being treated for that, or how they're being treated for that, or whether or not, treatments that are now illegal in Kansas for minors are being discussed or suggested, or in any way. So I suspect that a lot of people will do as you're saying, and they'll be focusing on anxiety, depression, the kinds of things that may be a part of that, without focusing on specifically on the gender dysphoria diagnosis. But whether or not, how we use that diagnosis may be a subject of future uh, discussion as well, in terms of what you document, and how you work with clients who may have that diagnosis, but also have other issues that may be a part of that would be an appropriate and probably safer focus for treatment. We'll stay tuned. This is a work in progress.
Yeah. And,
Okay.
and I would say too that the bill itself is only about 7 pages long. So if anyone has not actually looked at the language of the bill, I would encourage anyone to read through that. I know that there has been a lot that has been said about the bill, but since it is such a short bill, I would encourage everyone to take a look at it and be familiar with just the actual language in the bill. And yes, the board will continue to review information and try to understand it better ourselves.
Mhm. Okay.
In terms of the remainder of my report, I just, every time we have a advisory committee meeting, I am charged to keep the advisory committee members updated about recent work of the board from past board meetings. So I just wanted to briefly touch upon the, I mentioned the special board meeting the board had yesterday. There was also a full board meeting that was on January 13th. And so at that board meeting, the board did receive and by the way, Cynthia, I just want to let you know, so Andrea is in attendance and Leah and Gingery also just logged in as well. So they are,
Okay. Great.
and so at that board meeting on January 13th, there was an advocate for the Kansas Art Therapy Association. They are supporting a bill this session for art therapy to become licensed. And so that bill has not received a hearing, but it is assigned to the House Health and Human Services Committee. There's also a position on the Kansas Fights Addiction Grant Review Board that has been a BSRB designee for the last few years. I was initially the board's designee on that in that capacity, and an individual named Jason Hess has been in that role for the last couple of years. And Jason attended the meeting virtually and presented some information to the board about the work of the Kansas Fights Addiction Grant Review Board. So if you're interested in that group, you may want to go back and hear some of his comments from the meeting. We also talked briefly about the unprofessional conduct standards, the revisions for the different regulations. The board advisory committees have worked on those for the last couple of years in terms of really doing a comprehensive review and making good edits to those regulations. The final step really is we provided all that information back to the board, and we asked the board to review all of that to be ready to possibly discuss and vote on moving those forward in the process at the March board meeting. One of the things is that if there is an item that is missing for one profession, or if the board would want to have consistency on any issues, this would be an opportunity to decide that at the board level at this meeting. So that's one topic for the board to discuss. We also introduced a proposal for an expedited application review process and some language that we thought would be suitable for that process, and the board was receptive to that. So we'll have some language for the board to review in terms of regulations for that process at the March board meeting. And then there were a couple of recommendations forwarded to the board from the psychology and the master's level psychology advisory committee, some adjustments to some of their language. Part of that was trying to help those sets of regulations become more in sync with the changes to the definition of the term in residence. That was changed for 4 of the professions last year when the board decided to go ahead and open that definition up to make it easier for individuals from online schools to meet the qualifications for licensure if they came from non-accredited programs. So with that, I will go ahead and end my report and see if there's any questions on any of the topics that we discussed.
Hearing none, I thank you for your report, David. And we can move on now, I think, to the continuation of our annual training. If you remember last month, we had the first half of it, and I think we're going to finish up the second half today. Dave?
Yes, thank you. I'll go ahead and share my screen and we can get into the training topics. I also did want to highlight a couple of different documents I included in your packet of material for today. One of those documents I'll share on my screen here. Every full board meeting, I keep the board informed about licensing trends and totals. And I don't always share this with the advisory committee based on our limited time, but from time to time, since we are going through training and talking about BSRB totals, I just want to make you aware of this. I think this is helpful information. This is data that shows the trend in BSRB licensing over the last almost 10 years, from July of 2015 up into January of 2025. And what it shows is for the 16 levels of permanent license the board offers, it shows the increase in those levels. If you see the total here, back in July of 2015, there were 12,152 permanent licenses. And as of January 2025, that number has increased to 16,111. So almost a 4,000 increase in just the last almost 10 years. Now, on a line by line basis, not every line has increased. We've talked about our associate level social workers that we haven't been able to issue any new licenses in the last 40 years, but those individuals were able to continue to renew. We are down to 4, and there has been a decrease in certain levels, such as the bachelor's level social work per field. But we have seen a shift. And so people are staying in school longer and getting master's degrees. So we have seen an increase in the number of master's level social workers. That total has gone up by about 600 in the last 10 years. And then when you look at the clinical level of social work, that total has gone up from about 2,000 or 1966 back 10 years ago to now over 3,200. So that total has increased by over 1,200 clinical social workers. So we're seeing individuals stay in school longer and more individuals pursue an independent clinical level of license, which is great. Professional counseling is also another field that we've seen a lot of growth, and then behavior analysis. That's another field that we've seen a lot of growth as well. So just kind of wanted to take this as an opportunity to share that information with you. You also were provided a document that I shared with the board at the last board meeting. And in your packet of material, you will see a short report from a group called the Arkbridge Institute. And they put out a report on state occupational licensing. And what they looked at was licensing requirements between all 50 states and DC. And they ranked states. And if you look at that report on page 3, there's a map that shows different requirements by state. And one of the notable things from that report is it says on page 3, in 2024, the state with the highest occupational licensing burden is Texas, followed by Arkansas, Tennessee, Oregon, Alabama. But it also says the state with the lowest occupational licensing burden is Kansas at number 51, followed by Missouri at 50, Wyoming at 49, Indiana at 48, and New York at 47. So I think that narrative would be surprising to some people. And this is not just the professions under the BSRB. I want to make clear this was a lot of other professions, but it did include the ones, the BSRB licenses in Kansas. And so just thought that was interesting to kind of get that perspective from that group. If you want to see a much more detailed report, there's a much lengthier report you can click through to see, but just kind of wanted to highlight for you just to get a little bit of the information that we share with the board at the full board meeting.
David, there was a bill introduced in the Kansas legislature to eliminate occupational licensing. It didn't specifically name mental health licenses. I don't know if it's gotten a hearing, but do you know anything about that one? I just read about this like just a few days ago.
I believe that would be Senate Bill 229, and it would establish a sunset provision on occupational licensing requirements so that they would automatically terminate after 5 years unless explicitly extended by the legislature. It does exempt certain professions. So one of the professions that is exempted are healthcare providers regulated by the BSRB. So if it's the bill that is
Yes.
229, the BSRB would be exempt from that if it does move forward. It was introduced and assigned to the Senate Commerce Committee, and it did receive a hearing. It did not, I don't think it didn't move forward from that committee favorably, but it was assigned to the Senate Ways and Means Committee on Valentine's Day, February 14th. So that means it is not considered dead. It still lives. There's a legislative process by which we call something blessed as long as it touches an exempt committee. So since it was referred to the Senate Ways and Means Committee, it can move forward at a later time this year or next year. But at least so far, if it is that bill, the real big takeaway for us is that it excludes the BSRB, so we would not be covered under that bill. And that bill has not moved forward on the Senate side. It just received a hearing. So.
But if it were to pass, it could be a precedent. This has been a goal for a number of years of some members of the legislature to to do away with occupational licensing.
Uh,
So
it,
it's,
it could
it
be.
bears watching.
Yeah. Yeah, we'll continue to monitor that bill for sure.
Thank you.
I'll go ahead and share my screen here. And as Cynthia mentioned, we started the training for advisory committee members and board members last meeting. We got through about half of the training. And so we're going to take care of the second half of the training today. And so last time we talked about the role of the BSRB and then expectations for board members, advisory committee members, and then some general information about attendees of public meetings. And so now we're going to move to more of the legal requirements and the law that follows most executive level agencies for sure, and regulatory boards like the BSRB. So when it comes to professional licensing boards, Kansas regulates many professions through licensing boards or commissions created by the legislature to ensure professional competence and public safety. Boards are considered creatures of statute, which means the board's power is dependent upon its authorizing statute. The board can only exercise authority granted explicitly or implicitly by the Kansas statute. Boards cannot act beyond their statutory authority or on matters not addressed by law. Boards must adhere to constitutional protections, including things like equal protection, due process, and freedoms such as speech and privacy. And actions that are arbitrary, discriminatory, or violate rights, such as revoking a license based on a personal dislike, are prohibited. Legislature does still maintain authority over the BSRB. Legislature did create the agency, and it can control certain aspects of licensing boards, such as modifying the enabling legislation, which would change the purpose of the board. It could limit expenditures in an appropriations bill. If we have no funding for operations, we can't fulfill any functions. And then it could also enact new legislation to change the makeup, scope, or powers of the board. Some of the functions and duties of licensing boards, if you want to look at it under sort of a model, you could look at it as there are certain things that are close to executive authority, some that are judicial authority, and some that are legislative in nature. Under the executive authority, we do follow the Kansas Open Meetings Act, or the KOMA, and also the Kansas Open Records Act, or KORA, and we'll talk about those specifically. Under judicial authority, there's quasi-judicial hearings in reviewing facts when the law is violated, such as when the CRC or the Complaint Review Committee reviews certain allegations of misconduct. Additionally, we follow the Kansas Administrative Procedures Act, or CAPA, when that is appropriate. Under the legislative authority, we adopt rules and regulations to implement or interpret statutes with more detailed or specific requirements. And this process involves holding an open hearing on proposed regulations, allowing feedback, and there is oversight by a legislative committee. That's the Joint Committee on Administrative Rules and Regulations, or JCAR. Regulatory boards protect the public by ensuring that practitioners are competent and authorized through the implementation and enforcement of statutes, regulations, and internal policy. Board members and advisory committee members must understand the difference between statutes, regulations, and policies to effectively carry out their duties. So statutes are laws passed by the Kansas legislature, signed by the governor, and derived from the Kansas Constitution. Generally, those laws become effective on July 1st of the session year, and that's the language I talked about earlier when you usually see publication in the statute book. But you can have a different date specified in regulations, such as publication of the Kansas Register, or a specific date of January 1st of a certain year, for example. The statutes also define the scope of a board's authority and override any conflicting regulations or policies. And if a board requires additional authority, such as subpoena power, it must propose new legislation or request it. Second to statutory authority, regulations are in the next level of authority for the board. And these are rules adopted by the board to implement and enforce specific statutes. A board's authority to adopt rules and regulations is defined from statute, and it's developed under the Rules and Regulations Filing Act. So it ensures the public and legislative input, consistency, and legal compliance are included. Regulations fill in details of statutes affecting the rights and responsibilities of third parties outside the board. And once adopted in accordance with the Rules and Regulations Filing Act, regulations do have the force and effect of law and are legally enforceable. For a regulation to be valid, it must fall within the statutory authority, implement a specific statute, and comply with legal requirements and constitutional standards. Regulations that exceed authority or conflict with statutes or the Constitution will be voided. Then third, in terms of hierarchy, are policies and guidance documents. So policies may be adopted by the board only to guide its internal operations, such as prioritizing staff workload or explaining the investigative process. And guidance documents are things that state the board's current approach to or interpretation of law, or general statements of policy that prescribe how and when the board will exercise discretionary functions. And then there are some things we would recommend to make sure that you are being effective as a board member or advisory committee member. One, watch for conflicts. So be alert to agency policies or internal procedures that may conflict with statutes or regulations or that impact applicants or licensees. And be ready to initiate action. So if you see a statute or regulation that appears unclear or problematic, take steps to amend them or propose changes. In terms of discipline, the purpose of discipline is to promote compliance and protect the public. And discipline should not be vindictive or disproportionate to the severity of the violation. It is there to ensure that discipline is fair and proportional. And also an important item to remember as an advisory committee member and a board member, the primary responsibility of the board is to protect the public and not the licensee. Concerning professional activities, board members may hold office in a professional or trade association, but they cannot lobby for or vote on matters that affect both the association and their role of the board. Board members must not use their position to promote the interest of a professional association. Board members may attend professional conferences or social events, but must avoid discussing board business. And if a majority of the board is present, they must not discuss business affairs or matters related to a particular pending application or disciplinary matter. So we'll cover this more when we talk about the COMA, but it is important to remember to comply with those meeting laws. And Cynthia, did I see your hand raised?
Yeah, board would refer also to committee. So if several of the committee members here were somewhere, we wouldn't be supposed to talk about committee business.
That's correct. And we'll talk about there's three main requirements that usually fall into the COMA for that. And we'll make sure to kind of stress those.
Okay.
You're all aware of that. Concerning conduct, a board member should not represent themselves as a spokesperson for the board unless authorized by a vote of the board to do so. If unauthorized to give the board's position on an issue, members must clarify that any opinions are personal, not official board positions, and board members should not ask the board staff or counsel to provide legal advice or preferential treatment to any applicant or licensee. And now we're talking about the COMA, the Kansas Open Meetings Act. So the COMA ensures public access to governmental meetings to promote an informed electorate. The purpose is to benefit the public, so the COMA is interpreted liberally and exceptions are applied narrowly to carry out its purpose. It applies to all state legislative and administrative bodies, as well as subordinate groups funded by public money. So under this, subordinate groups are likely subject to COMA if created and extended by a covered entity. So for example, the board is a group covered by the COMA, but therefore also the advisory committees are official groups that are covered by COMA. And if there is a specific subcommittee that the advisory committees would want to form or the board would want to form, those subcommittees would also likely fall under COMA. Now, if you have a non-official group, just a few volunteers that want to get together and discuss something or work on something together, as long as it's not an official subordinate group, that's fine. And so we'll talk a little bit more about that too. The COMA does not apply to quasi-judicial functions or proceedings under the Kansas Administrative Procedures Act or the CAPA. It doesn't apply to the judiciary, private organizations, or staff meetings of covered entities. And the goal of the COMA is to ensure transparency in government decision-making for the public. Next, we'll talk about what constitutes a meeting. So the definition of a meeting is any gathering or assembly in person through the use of a telephone or any other medium for interactive communication by a majority of members of an agency or public body subject to COMA for the purpose of discussing the business or affairs of the public body or agency. So we'll kind of pause here and make sure that this is really clear. There's three components that need to be necessary for the COMA to take place. One, it has to be a group that would be subject to the COMA, and so the BSRB board or the advisory committees would fall under that. There would need to be a majority of members of that group. So if you had half or less than half, that would not apply to the COMA. But let's say you had the majority of members of that group. There's also a component of interactive communication. Now that could be you're all in the same room talking back and forth. Of course, that qualifies. It could be you're all on the phone talking to each other on the phone. It could be that you are sending emails back to each other. And that's why you need to be careful not to hit reply all on emails, because if there's a back and forth component, you get into the discussion. But then the last component is it would have to deal with the affairs or the business of the covered entity. So if all the members of the advisory committee wanted to go out to dinner and didn't talk about anything to do with the work of the advisory committee, that would be fine. You would still have a majority of members. There would be interactive communication, but it wouldn't be about the business or affairs of the group. Similar if you went out to go see a movie together or something like that. You probably wouldn't have the interactive communication, but also you're not dealing with the affairs of the business. So if you all attend, the same conference or something like that, that would be fine too. You just need to be careful when it comes to a majority of members of the group that there is interactive communication and the subject has to do with the business or affairs of the public body. And like I said, it doesn't have to be just a meeting in person. It can be over the phone or other electronic means. And then when those things are all included, the COMA does apply. It also can include informal discussions before, after, or during recess of a public meeting, all gatherings at any stage of the decision-making process. That can include things like work sessions or retreats that are subject to COMA. So when we have the board's out-of-town planning meeting that we do once a year, those are always open to the public. We always put out notice about those. And I believe all the ones that I have been to so far, we have had at least one person from the public attend those meetings. And so those are open and under the COMA. Also, in terms of the discussion, that does not require binding action or voting. It can occur at social gatherings, retreats, or meetings held in private, and educational conferences or seminars. So when traveling to such meetings, members of the board should avoid discussing agency affairs or business if it does involve a majority of members of the board or the advisory committee. Also under the COMA, the presiding officer must provide meeting notice, but that is generally delegated to staff of the BSRB to make sure that we follow that. Notice is not required to be published in the paper or on a website, but individuals must request it. And the request for notice can be verbal or written and are valid for 1 fiscal year. And the notice must include the meeting's date, time, and location provided in a reasonable time before the meeting. So we take care of all of that. We always publish an agenda on the BSRB website. We also post notice of meetings on a website called the Kansas Public Square. And then we also have an email that goes out to individuals who have specifically requested public notice of meetings, so they get information once we provide public notice of a meeting. The COMA does not require following the Robert's Rules of Order or any similar formal rules of procedure. The COMA does not require the board to create an agenda, but if one exists, it must be made available to the public. Meetings may be recorded if doing so is not disruptive. The public does not have the right to speak, but they do have the right to listen and observe, and secret ballots are prohibited. Concerning minutes, a board's policy may require minutes to be kept, but the COMA does not require minutes unless an executive session occurs. If there is an executive session, the motion to enter executive session must be included in the minutes. And if you have an executive session, that permits discussion of certain enumerated matters outside of public view. You cannot result in binding action in the executive session, but a consensus is allowed, and any consensus reached must be formalized in an open session vote. So it is unlikely we will have very many executive sessions as an advisory committee, but if that ever does happen, we'll be very careful and make sure that you're all aware that we are about to go into executive session. There will be a formal motion. Usually I pre-draft those, and then I ask a member of the group wants to make that motion. The executive session is held outside of the meeting. And so what we usually do is these meetings are broadcast on YouTube. If there is a motion to go into executive session, the broadcast will continue, but we'll generally do the executive session in another way, usually over a confidential conference call line. Yes, Cynthia? I think you're muted right now.
Yeah, sorry. What kind of enumerated topics are allowed to be discussed in executive session versus in the full public meeting?
That's a really good question. There is a specific statute in Kansas that lists about 10 to 15 different topics that are allowed to be discussed. One of the most popular areas that can be talked about, you can get attorney-client information through the confidential relationship of legal counsel with the group. So if it's attorney-client relation information, that information is subject to the executive session. If there are personnel matters, personnel matters are covered by that. There is also some language that does talk about, I believe, safety and security type things, like maybe cybersecurity for an entity or something like that. And then there are very specific exceptions that are covered in that statute that are related to like one specific group or another that may have to do with physical security for a certain group. But there is a statute, and I can get that for you if you'd like. But yeah, that statute does outline different reasons you can go into executive session. And then in your motion for executive session, you do want to cite one of those reasons for why you are going to executive session.
Okay, thank you.
Yep. If there is someone is alleging a violation of the COMA, those are civil penalties, not criminal. And any person, attorney general, or county district attorney may bring an action in district court. The county or district attorney and attorney general may have subpoena power, and enforcement actions take precedence over all other cases and are assigned for trial at the earliest practical date. Some of the remedies for a COMA violation could be voiding any action taken if prosecuted by the attorney general or county district attorney, an injunction, which would be stopping an action, a mandamus, which would be forcing an action, or a declaratory judgment. There's also potential monetary fines, and these would go to board members or advisory committee members if there is a violation. There could be an ouster from office, a recall from office, court costs assigned to the person seeking enforcement of COMA, or alternatively, there could be court costs assigned against a plaintiff if they maintain their action frivolously or not in good faith or without reasonable basis in fact or law. So we do take the COMA very seriously. We always are very proactive in terms of trying to get information out there, make sure that we have met our standard and the public is aware of meetings. Moving next to the Kansas Open Records Act, or KORA. Under the statute, it mandates that public records be open for inspection by any person unless otherwise prohibited. KORA is designed liberally to promote such policy. So it includes state, political, and taxing subdivisions, offices, officers, entities that receive public funds. And while not explicitly defined in the KORA, entities created or extended by a covered agency are typically subject to the KORA. So the work of the board and also the work of the advisory committees could fall under the Kansas Open Records Act. Concerning public records, these include any recorded information that is made, maintained, kept by, or in the possession of any public agency. It does not include records that are owned by a private person or entity. KORA does not apply to private companies, even if publicly funded for services, judges or courts, individual legislature or governing body members, or private individuals. Under the KORA, the board must appoint a Freedom of Information officer to assist with KORA requests, provide a brochure outlining requester rights, agency responsibilities, and procedures for inspecting and obtaining copies of public records, and include contact details for the records custodian, fees, and office hours. And all of this is maintained in policy under KORA for the BSRB. If you ever go into our physical office, we keep a copy of this right next to the clerical assistant desk. And then it's also available on the BSRB website under the drop-down for policies. You can find it there as well. And Leslie Allen is appointed our Freedom of Information officer, and she assists with those KORA requests. Under the KORA, anyone regardless of residency can request records. Individuals do not need to provide a reason for requesting records. The board may require requests to be written with the requester's name, address, and proof of identification. And the board may also require the requester to sign a written certification that the requester will not use names and addresses obtained from the records to solicit sales or services. And the board cannot deny a person the right to review public records unless it's closed by law. If portions of the record are closed, the remainder must be made available to the requester, such as by using redaction. The board is not required to make copies of the following unless shown at a public meeting: recording tapes or discs, videotapes or films, slides, graphics, or illustrations, and requests must be responded to within 3 business days. With the 3 possible responses. 1, either the record is provided in the form requested if possible, the request is under review and the records will be provided if permitted, or the request is denied with a more detailed explanation for the denial. So when we receive a KORA request, it does go to Leslie. We basically review to see if we have those that we can easily provide back. If it's going to take some time to review our records to see if we have anything matching that description, we send something in within 3 days to let them know it's under review, and we will follow up once we have those records. And then if the request is denied, it'll explain why we were denying that request. Sometimes people might request certain information for an active investigation, and under the law, when something is still an active investigation, that information is not available under a KORA request. Public records must be released unless an exemption to disclosure applies, and the burden is on the board to provide exemptions, and exemptions can be discretionary or mandatory. If there is an allegation of a core violation that is similar to the COMA, it's a civil act, any person can bring a civil prosecution. And then similarly to what we talked about under COMA, there are different types of things that could be sought. Potentially, there could be a monetary violation for a knowing violation or intentional failure to furnish information, and costs and attorney fees to be imposed if denial is found to be in bad faith or without a reasonable basis in fact or law. And violations are subject to trial at the earliest possible date. One of the things to remember about the CORA, and I know you all don't need this as a reminder, but I still do it every year just because it's good practice. Traditionally, people have thought about records as, you have an official paper document, but now we do so many things electronically that we have a lot of documents that never actually get printed in paper form. So those electronic items are still, if they're kept in the normal course of business, they are still a record, and so they would be subject to the COMA in certain situations. Additionally, things like email, we always tell people these emails back and forth that affect the work of the BSRB, these also could be records. And so while we know everybody is really formal when it comes to writing professional letters, sometimes people are not always as formal with the language they might use in an email. So we always encourage people to just be professional in your correspondence because they always say, imagine if one of these emails was printed in the paper, how would you feel about that? So we always like to pause a note here and then to encourage everyone to make sure you're professional in your correspondence. Moving next to the CAPA. So the Kansas Administrative Procedures Act establishes procedural rights and duties. It does not provide substantive law. Substantive laws are governed by the board's Enabling and Licensing Act. The CAPA applies only when explicitly stated by other statutes. It also governs the board decisions when specified in the licensing or enabling statutes. It ensures the board operates efficiently and in accordance with the law, while also balancing public access where appropriate. Licensing boards in general must conduct business under the COMA in open meetings, but when statutes direct decisions to be made under the CAPA, the board follows the CAPA rather than the COMA. So CAPA and COMA are mutually exclusive, and we'll talk about a few examples where we use the COMA versus when we would use the CAPA. The CAPA sets out a procedure to follow when the board is deciding what to do in cases involving individual licensees. In these cases, the board conducts a quasi-judicial function in deciding the outcome of the case. So if the board is having a discussion that's going to apply to all licensed applicants in one profession, well, that's not specific to one specific licensee, and there's no reason that we would need to hold that in a confidential session. So that's something that we would talk about in an open meeting. But if there's one individual applicant and they have a problem with their application, and this needs to go before the board due to privacy concerns, that is handled under the CAPA proceeding, and that is in a closed session. The CAPA does not require public notification for licensure application reviews or complaint review committee or CRC meetings, including probable cause determinations and summary proceeding orders. Only hearings need to be open to the public under CAPA. So if there is a complaint filed against someone, the complaint review committee reviews those, determines there is a violation. That would be a legal order drafted by legal counsel sent to that person. And if they requested a hearing, which is one of the rights they have, that hearing would be public. So at that point, there is public access to the hearing. But prior to that, it would be under a closed session. Decisions are made upon issuance of a license to order and public voting is not required. And during CAPA proceedings, relevant board staff or legal counsel may attend to provide necessary information and legal advice to board members. Board activities that are not covered by CAPA and must be acted on in an open meeting under the COMA include things like approving board minutes, deciding whether to renew contracts or change the way contracted services are provided, delegating authority to a board member or executive director for particular action, discussions and votes to approve or amend regulations and guidance documents, policy decisions affecting the way the board operates internally, receiving agency updates regarding the budget, legislation, statistics on complaints and CRC activity, education, executive director's report, et cetera, et cetera. Under the applications for licensure, applicants have the burden of proof, and staff will collect necessary information for the board to assess whether the applicant qualifies for licensure or if conditions or restrictions apply. And if the board does condition, deny, or restrict a license, the applicant may request a hearing unless agreed to in a consent agreement in order. Under the investigation, the board has the burden of proof to show that a licensee has violated the statutes or the regulations, and licensing boards can investigate complaints, with the investigator presenting findings to the CRC. The CRC determines if there is a probable cause to review a violation or to believe a violation has occurred based on reasonable grounds. And reasonable grounds essentially means information that would lead a reasonable, prudent person to believe that a licensee violated one of the board's statutes or regulations. Under the investigations, the CRC must ensure the licensee's conduct that they are accused of actually violates one of the board's statutes or regulations. A licensee doing something that made someone angry, violated a professional association's ethical code, or did not follow an employer's policy does not necessarily mean they have violated a statute or regulation. Licensees can request a hearing within a certain prescribed time period, and once a petition or request for hearing is filed, the CAPA guides the proceeding and the hearing does take place. In cases where there is immediate danger to public health, safety, or welfare, the CRC may suspend a license without giving the licensee notice or an opportunity for a hearing, but the licensee may appeal the emergency order to the district court. So the CAPA is more applicable to actions by the board than the advisory committee members, but if we ever do need to go into a CAPA proceeding, we will let you know, and that will be closed. So we may still use Zoom to do some of those CAPA proceedings, but they're not broadcast on the BSRB YouTube channel. There's not a requirement for notice like we talked about. It's a different format, but we're either doing things publicly under the COMA or closed or private under the CAPA. So, and then the last item I'll talk about before we end the training here is the Kansas Tort Claims Act. The Kansas Tort Claims Act governs the liability of the state of Kansas and its agencies and employees, including board members, elected or appointed officials, and others acting on behalf of the government. The Tort Claims Act establishes vicarious liability for wrongful acts or omissions within the scope of employment with potential case-by-case immunity. The essential thing to note about the Tort Claims Act is that if you are sued for actions within your duties as a board member or an advisory committee member, the state will defend you at no cost. But there are certain requirements, and so it's really important that you know what's required of you should this ever come up. To obtain representation by the state, you must submit a written request within 15 days after service of process and must include a copy of the petition and the summons, and then also cooperate in your defense. The state may choose not to defend you if you acted with actual fraud or malice, failed to make a timely request for representation, or the judgment is for an action or omission that occurred outside the scope of your duties as a board member or advisory committee member. So I have never seen this come up in the now on 5 years that I've been executive director for the board. I hope it never does come up, but I do think it's important to let you all know the work you're doing on the advisory committee is very important. And should you ever get notice that you are being sued because of your actions as a board member or advisory committee member, please let us know as soon as possible, and we will make sure that you get representation for those actions. But like I said, I hope it never comes up. And then just in conclusion for the training, what we recommend is that you become familiar with the statutes and regulations for the different professions, and those are linked on the BSRB website. We recommend that you review policy documents, including the expectations for board members, advisory committee policy, and guidance for attendees of meetings, and become familiar with the BSRB website, YouTube channel, and other resources available to you to use as a board or advisory committee member. And again, the address for the website is ksbsrb.ks.gov. And we recommend that you strive to uphold the values for board members and advisory committee members, and be mindful of the laws and requirements related to state agencies such as the COMA, the CORA, and also the CAPA. And then just my contact information is on the back there. I did also want to thank Emma again. You may recall I mentioned her. She is an employee with the BSRB who's taken on some roles to act as my assistant in certain ways, and she was very helpful in trimming down the training from about 150 slides down to 70. So it is a long training. It does cover a lot of materials, but this is really important information for you to hear and be mindful of. And so I do want to thank her for all of her hard work on that. But I'll go ahead and stop here and see if there's any questions from advisory committee members.
David, I would just, the last slide about becoming familiar with the regulations, just the regulations for social work is a lot, and we should all be aware of those, or and know what they are for our own practice. But what is it important for the advisory committee members to be familiar with the regulations for the other professions? I know it is for board members, but the advisory committee is profession specific. So in the training, are we saying that committee members need to be familiar with the regulations for all the professions that the BSRB governs?
You know, that popular phrase, as time allows, um, when you're looking for new ways to expand your membership on the advisory committee, I do think it's helpful for comparison. It's something we try to do on behalf of the board and the advisory committees is to look for things that, um, and Lee, I'm getting some feedback from yours, but
Oh, sorry.
no problem. Yeah, we do, you know, I think it's a good idea for, you know, first and foremost, focus on the ones for social work. But then as we're looking at a certain topic, it's not a bad idea. If we're talking about something like continuing education, you know, some of the similar regulations, because for most of the professions, there is an identical regulation, not in substance, but in title. And you can look at these other ones and say, oh, well, this profession included this. Maybe that's something that we should consider including in this to recommend to the board. Or maybe they have a certain number of hours for whatever. Or maybe there's, you know, on the requirements for licensure and the educational requirements, maybe there's a different profession that looks at it a certain way and has coursework level requirements or program level requirements. And so we do try to, you know, standardize some of that, and we try to line up the professions, knowing that there are going to be some unique differences. But at least for comparison, that's also something to be helpful to take a look at that. But we also realize there's a lot of content out there. So we really don't think, you know, we wouldn't expect you to know all the regulations and statutes. So primarily focus on social work, and then as time allows, look at the other professions too.
And all of that is available on the BSRB website.
It is. The statutes are linked to the Reviser of Statutes website. So that is the official entity that drafts the statute. And then for the regulations, those are linked to the Secretary of State's website. And that's where the KARs or administrative regulations are hosted. So you can just click on the link and it live links to those sites.
Okay, thank you.
This is Mike. I've been one that has tried out the CE brokers and the different kinds of programs just because I think it's good to see how does it work and does it work. The license verification program, I keep checking it because it seems rather klutzy, and it doesn't, the more information you put in it, the less ability it has to identify a person's license. And so I tried different things for my name, and it came up with my driver's license number into the blank. At first, I just scratched my head trying to think, what is this number? And then it dawned on me, that looks like a driver's license number. And I thought that was bizarre that it would put that kind of information onto a public facing site. But I did put David, your name in to see if it would give me your driver's license number, and it didn't. So you can rest assured, a general public person, it didn't just access everyone's driver's license number. But anyway, I just thought that was kind of odd.
That was CE broker, not
No,
not
no, no,
BSRB site.
the BSRB site.
Really?
Right, right.
Mike, I might have to follow up with you about that, because I was looking at the license verification portal, and I just typed in your last name and pulled you up. I don't see a driver's license number on here, but let's
Yeah,
I
yeah,
want yeah.
I was messing with, do I put the name, do I put the license, do I, so partial information instead of maybe my name, you know what I mean? And it came up. And that happened I only saw that one time, but I thought that was bizarre. So I thought, let me try some other names, and it didn't do that. So I thought, well, maybe it was just a weird fluky thing.
Hmm.
But yeah, anyway, that program seems to be a little bit funky. That's all.
Okay. Well,
Anyway,
I know the state we are switching over to the new licensing system here in a couple of years. We're in the process of them doing discovery on all of our forms and trying to put those into the system. And one of the things they're also working on is creating a unified license verification portal for different regulatory boards and licensing agencies in the state of Kansas, kind of a one-stop shop. So we will continue to have our verification portal on the website, but there will in the future be a spot where anybody can go and type in somebody's name and see if they're licensed as a nurse or a psychologist
or
or
whatever,
whatever.
barber or whatever.
Yeah.
Right.
So
All
that'll be,
occupational licenses then will
yeah,
be in that same portal.
it will. Yeah. And it'll link directly from existing portals like the BSRB's one. So we will still have bars, but
Mhm.
And with that, I thought about school psychologists because they're not regulated by the BSRB and they're not regulated by the healing arts. They're through the Department of Education. Excuse me. They just seem really odd to me.
yeah, they should be included there when it all gets finalized. But you're right; those are under the Department of Education.
So they're licensed through the DOE?
They are. Mhm.
I didn't realize that. Any other questions or comments about the training?
I don't have any. This is Lee.
Thank you. Okay, well, yeah, it was a lot of material to cover, but those slides were attached to the email you sent, so you can go back and review if there's something that went by too fast that you didn't quite absorb for future reference. So, okay, thank you, David. And I think we can move on to old business. We have been working on the social work supervision manual, and we do have a final draft of the timeline that we created for people who are getting ready to supervise, so they kind of step by step can know the different tasks involved. And I believe that David has a steps to licensure once people have completed their training, et cetera. Did you want to put that up for us, David? This was something that at the board's retreat uh, last fall, we were able to look at these different step by step how to get licensed pieces that were created. And I think they've been a little bit tweaked since then, but do you have that for us, David?
I do, and those are included in your packet of materials as well. So we wanted to kind of help individuals when they apply get a better understanding of the different steps that are involved. And so our licensing staff worked on just a little two-page demonstrative. And as I mentioned, this is in your packet, it's on the website. But basically, it just kind of shows when someone applies for licensure, what are they required to do, and then what is the next step. And so you have the applicant step followed by what the staff is going to be responsible for, and then sort of their communication, and then what happens if something is not taken care of, what happens in that case, and then following along and moving through the process. And we did one of these for most of the professions under the BSRB, but yeah, we are tweaking these and cleaning them up. The ultimate goal is we hope to put these on the website. And then for the social work, we can include these with some other materials for the manual as a quick little demonstration in terms of applying for license. But this is the path towards licensure when someone applies for a clinical license and the steps they take. And then the other document was path to licensure if someone is licensed in another state or country, and they're applying to the BSRB for licensure through reciprocity. And so it kind of walks through the steps there. It's a little bit of a different process, but it kind of explains what the applicant is responsible for, what our staff is responsible for, and then the timeline of those different items. So I wanted to show this to you. If you have any suggestions or comments, please let us know and we can tweak this. The other information that Cynthia was talking about in terms of the supervision manual is being reviewed. We wanted to make sure that we had legal counsel for the board get the opportunity to review that and weigh in on some of the language there. And so that's taking place now, and we should have that back for you between now and the next advisory committee meeting.
So Tim's working on that?
Yes, he is.
Okay. Yeah, so then once that's review is complete, then David will distribute that final draft to the committee so that you can review it before our next meeting. And hopefully then be able to give it our final approval to be placed on the website for those contemplating supervision. Okay, so any questions about the timeline or comments? We thought it was really helpful to have it outlined step by step like that. A lot of people seem to get confused about what the various steps are and what stage their application is. So the next thing we had under old business was review and discussion of the ASWB reports. We've had that on our agenda for several meetings. There were 3 different reports, and I think David distributed those a couple different times in our previous meetings. And so I don't know if everyone's had a chance to look at those. Are you able to put any of those up for us, David?
Yes, I can do that. And just to kind of frame this conversation, these were reports that were commissioned by the Association of Social Work Boards, ASWB, but the actual review and the content for those reports was put together by a couple of independent researchers. They are Dr. Joy Kim and Dr. Michael Cho, and they are from the Rutgers School of Social Work. And so while the work was commissioned by ASWB, these are independent findings and reports, and thought it would be helpful for the different reports to be reviewed and discussed by the members of the advisory committee. The first report focused on the profile of a social work license examinee. And so, and pulling that up now, and I'll go ahead and share my screen once it is, once it opens up.
And I will say that the first, her name, say again, her name, the doctor.
Dr. Joy Kim.
Yes, she was at the ASWB meeting that David and I attended in San Diego. Very sharp. She definitely knew her stuff, and I think this is really valuable information that she was able to collect.
So I wanted to open this up for any of the members of the advisory committee to discuss these reports, and thought we'd start with the first one. You've had a few different meetings now to review the content. Each of the reports is about 30 to 50 pages, I believe, in length. Do you have any comments or any notable takeaways from the first report that looked at the profile of social work license examinees?
Here's your.
And if there's a specific part of the report you'd like me to go to, there is information that does talk about demographic characteristics, such as things like gender, race, ethnicity, age, disability-related accommodations, English as a second language, regions of residence. And then there's also some educational characteristics, such as applicants that had an associate's degree, a bachelor's degree, or the age at which they obtained their master's degree. And then some employment characteristics, and then exam decisions, such as the age of the first exam attempt and the number of exam attempts.
I thought the data about first exam attempts was interesting. Remember that these reports were commissioned as part of the ASWB's efforts to understand the differential pass rates that They released that data for that a couple of years ago now. And so there were differences. Well, this is just showing overall, but amongst the groups in that first, the demographic groups, there was a difference in what the age was at first attempt to take the exam amongst those different groups. Are we finding them?
Yeah, and if there's a certain
Here it
chart on
is.
a
This
certain
is what I thought this was really interesting. That essentially there is a correlation between higher pass rate and being younger when you take the exam, and how long you've been out of school before you take the exam. Overall, there were those differences, and then within demographic groups, there were differences as well. Like, for example, how in one demographic group, the age at first attempt was older or younger, and how long it was past graduating from school was differential in different demographic groups.
You know, one thing that I found interesting was for the overall totals, you know, it showed the age by which individuals are obtaining their bachelor's degree, and the median was 23. The mean was about age 26. The age at which most individuals are obtaining their master's in social work, median age of 29, mean age of 31. And then, so once someone has their master's degree, and at least in Kansas, when they get their master's level license, they complete the 3,000 hours of postgraduate experience over not less than 2 years towards getting their clinical level license. And yet, on average, the number of years by which it was from when they got their master's to when they took the exam for the first time was about a 6-year difference, which surprised me. You know, I know that there are going to be individuals that are going to wait a longer period of time to do that, but just looking at everyone in total, the average, I would have thought it would have been a little closer to about 3 or 4 years versus 6 years difference between waiting that long and taking the clinical exam. So.
Well, is that specifically to first exam attempt is for, it doesn't say specifically it's clinical, or I guess it says it underneath there.
Yep.
So that's not the age of their first exam attempt at their MSW exam. This is the LSCSW, or the clinical exam. Yeah.
Yeah, I was comparing kind of the age of when they got their MSW, but you're
Mhm.
right. If they don't pass the master's level test, then there would be a longer period of time there too.
So that may be part of that reason if people had trouble passing the MSW exam, but also they're not going to take the clinical exam until they've finished their clinical supervision hours. And that can take, some people wouldn't necessarily start that right out of their MSW. They might not get a job where they had access to supervision, or they might not be doing clinical work right away. Does anybody have any
it's
other
still,
thoughts?
I mean, 6 years though is still a longer period of time than I would have anticipated. So that's a good data point.
Yeah, and I think that certainly could contribute to difficulty passing an exam if you're that far out of school. One of the things that's been talked about is whether people should be allowed to take the exam earlier, or take the MSW exam even while they're, still in finishing their MSW program.
They can take it sooner. I think February was sort of the time frame where you could take it when you were didn't graduate till May.
Oh, really? Okay. I didn't know that. That's good.
I think
That's
it's
good.
either 90, 120 days before graduation, something along those lines.
Well, that's helpful. But then if it's 6 years before you take the clinical exam, that's a long stretch to try to retain information that you learned in school.
Any other takeaways from reading this first report that tried to quantify the profile of a social work examinee?
Or any other thoughts about why some of these differences exist?
I honestly, I think this reflects what I've seen in practice and what I've known who passed or didn't pass, and just kind of the dynamics with that. I've also noticed the school that does make a big difference as well, where they go to college.
Absolutely, because the different colleges um, have different data on that. For example, I think it was UT Austin that did not have the differential pass rate that they found across most other schools. And that original report that the ASWB put out had school-specific data. So if anybody's interested in looking up your school or a school that you're associated with, or you can go back to that original report on the ASWB website and look that up for yourself. KU did pretty well, as I recall, but I don't remember about the other Kansas schools. Did anybody else look up?
I didn't. I mean, nothing against the school, but WSU's program.
The what
People
program?
WSU's, the
Oh,
people that have come out of that have had trouble passing the exam. Their writing skills are definitely not the same.
interesting.
Yeah, I've just seen that a lot. Obviously, I mean, in Wichita, you see a
Mhm.
lot of Wichita people that come out of Wichita State, but and it's so hard to compare from when I went. There was only one grad school when I went, and I was atypical. I went straight through. I didn't wait, but that's very unusual. Most people kind of sit for a minute and then they're like, no, I'm going back. I feel like and maybe I just didn't pay attention before, but like more people, and they get into child welfare and they get a job with us, and then they leave and decide to go back to school quicker than I remember people doing that before. So like the age that they're then going to grad school, whereas before, I mean, when I went, it was really mostly non-traditional students who were working or had worked and then were coming back. So I mean, things just really change over time. I guess I'm more like, okay, what do we do with this information now that we have it?
Mhm. Yeah.
Yeah, and to that point, I'm curious. You know, the first report really focused on the profile of a social work examiner. I'm gonna share my screen here. The second report talked about the determinants of license exam outcomes. And I'm curious if any members of the advisory committee had comments or takeaways about the second report, and some of the determining factors that they were looking at, just in terms of the executive summary, that some of those determinants they were looking at had to do with socio-demographic characteristics, academic background and performance, exam timing and preparation, and then for institutional factors, type of educational institution, admission selectivity, and percentage of students on Pell Grants, faculty characteristics, program size and geographic location, and then in terms of community factors, segregation, inequality, and socioeconomic status. So any takeaways from the second report that was really trying to dig in and look at determine.
Can you leave it out here on the summary for a second so we can refresh our memory about right. Yeah, I remember that. Being younger, having a higher GPA, these are things you might assume, and high scores on admission tests, and who don't delay taking the exam once they are eligible and can study sufficient hours. Those are all factors that I think most of us would identify as increasing your chances of passing, right? Likewise, the institutional and community factors they identified. Hmm.
one of the members of the advisory committee did comment about um, some of the different results based on which schools had different results. And I think there was one school in particular that was noted that had a very high pass rate. And so there was a comment. I don't remember if it was this report or the third report, but there was sort of a suggestion of perhaps some of those schools that are overperforming the national average maybe should be examined to see
Yes.
how the schools are doing compared to other schools. But I thought that was kind of interesting. Um, some of this report also takes a look outside of just social work, and it looks at other standardized tests. There's a note in here about the pharmacist licensing examination. I think they reference also the nursing examination in terms of collect. I think there's some comments about the bar examination at certain
Yes.
points. So a lot of good data. I thought the researchers really did a nice job of trying to expand the conversation, at least to look at different characteristics, not just limited to social work, but looking at other fields as well.
Right. The same differential exists across many occupational licenses and in psychology as well. They've had a similar data on their pass fail rates.
One of the comments here on page 12, strongest predictor of bar exam pass for all examinees were adjusted law school GPA and LSAT score.
But again, that of course then begs the question of, I mean, that's just an extension, what makes someone be able to have a higher GPA or higher LSAT score and be better at testing, that pre-exists them taking the occupational exam. It's probably been a differential all the way through their education.
We've talked about this already today, but there was a finding that the longer there was between exam eligibility and exam taking were associated with lower pass rates. So the longer you wait to take the test, when looking at all the groups, tend to be that the worse they would do if there was a longer period of time there. And I know in the past, the board did try to make an effort to say if someone gets a certain window of time to take the exam, we would want them to try to take the exam within the first 6 months. But it got really difficult from what I have heard to track that and enforce that. And so that is not a requirement, but that does kind of fit into the narrative that I'm seeing as part of this exam too, or study.
Yeah.
I know that we're getting close to the end of time today, but
Right.
for the third test, it looked on the effects of race and ethnicity and clinical exam outcomes. I'm just curious if there's any comments on that third publication. If any advisory committees had members had takeaways or anything they wanted to discuss on the third report here.
Can you bring up the summary page again on that one? Executive summary at the beginning. So what does anybody think about this factor as far as they seem to be saying that some of these other factors had a greater impact than ethnicity and race. How does anybody else read that?
I think it goes on the individual. I think it both could impact.
Mm-hmm.
I think it's only opinion. Each individual, one or the other, could impact more or the same.
I think probably just your education and not just college, but like Wichita is not major inner city by any way, but we do have inner city schools
Sure.
and
Mhm.
the education there. So it just kind of starts out weak. And then that's where Wichita State pulls from is, our community. We're not pulling from Kansas City. And so, a lot of, also, I'm trying to think probably more non-traditional students because the people that live here may then go back to college than
Right.
other, K-State, EU.
So of course, the $64,000 question that all of this data and research was designed to help us ask and answer is what can we do about all these differentials that they identified? Where can we, how can we equalize pass rates for all of these groups that have differentials? And obviously, we can't answer that question today, but I would encourage us all to be thinking about that in terms of uh, what interventions could be done to improve pass rates for all groups that have a lower pass rate. All those different factors that, yes, vary from individual to individual. So we'd be looking on both the micro and the macro level to see what we could do. One of the suggestions I know that has been thrown out was the idea of offering mentorship, having volunteers that have passed the exam, be assigned to those that request it to help them prepare for the exam. That's just one thought that that we've discussed briefly, but there could be many other ways that we might help people improve their pass rates. That's kind of the ultimate goal of all of this research. So we are about at the end of our time now. We do have our next meeting scheduled for Tuesday, April 8th. And I did just want to let everybody know that the NESW has a new piece out that they've developed about AI. We spent a whole meeting talking about AI a few months back. So any of you that are interested in what they've put together, I think you can get it from NESW website. I will try to maybe download that and send it to David to send out to everybody for our next meeting as we continue our discussion about AI down the road. Any other thoughts, comments, or requests for items to be put on our next meeting? Hearing none, I would entertain a motion to adjourn.
This is Lee. I motion to adjourn the meeting.
Thank you, Lee. Do I have a second?
I second.
Okay. All in favor? Aye.
Bye.
Great. Everybody have a great week, month, and we will see you on April 8th.
Thanks, everyone.
Mhm.
Bye.
Bye-bye.
Thank you.